:57 a.m. on May 16, 2024. Court marks operated by our court clerk, Sue Hall. Our official court reporter is present. She is the official record. The court mark recording is not available for release. This is the matter of state. This is Christopher Greger, case 21-1881. Would counsel please put their appearances on the record this morning?
Your Honor, Christine Lento, appearing on behalf of the state.
Assistant Prosecutor Jamie Schroen for the state.
Good morning, Ms. Lento. Good morning again, Ms. Schroen. Good morning, Your Honor. Mario Gallucci, along with Andrea Ferrante, on behalf of Mr. Greger, who's seated to my left.
Good morning.
Good morning, everyone. Thank you. Mr. Greger appears in court again, appropriately attired in a blue suit and a white shirt and necktie. I just received a message from the jury manager that they're still waiting for 4 jurors to arrive, and will advise me when all are present. Mr. Gallucci, you have witnesses for this morning?
I do, Your Honor. I have Detective Sergeant Raymond Coles. I have Patrolman Daniel Dugan from the Barnegat Police Department. I have Patrolman, I think it's Angel Roman from the Barnegat Police Department, and potentially Detective Dennis Mitchell from the Ocean County, I believe he's part of the prosecutor's office, right?
Correct.
From the Ocean County prosecutor's office. We endeavored, actually, the state endeavored on our behalf to track down the Seabright police officer. They were not successful. We're in the process of preparing a subpoena for that witness and other witnesses from Seabright, all dealing with the same issue. And hopefully we'll have them available next week.
Very good. Do you need anything from the court with respect to any hearing on that? I'll be happy to help you with that.
Thank you, Judge.
All right, anything else from counsel while we're waiting for the jurors?
No, Judge, thank you.
So we need to tell this jury today when they're going to report again. Does anybody really anticipate having a witness or witnesses on Tuesday, May 21, or we're just waiting for Dr. Feingold on Wednesday, May 22?
Judge, I mean, the subpoena I asked for the Seabright officer could be potentially for the 21st if you wanted to work that day, but I would assume that testimony would be less than 15 minutes.
Right. I really hate to, I mean, one thing yesterday, we brought him in for at least the majority of the morning. I
Right.
really hate to bring him in for 15 minutes.
So, I mean, I defer to court as always, but I don't think that Dr. Feingold is going to be a whole day. And I'm sure that if we could get these Seabright cops here, that the 22nd would be fine. If you want us to appear on the 21st and do a charge conference, I'm all yours.
That probably makes more sense, I think. And if need be, if there's some issues with the officer, you can bring him on the 24th as well.
Right.
All right, so I don't anticipate these witnesses are going to take you the entire day, right?
The witnesses this morning?
Yeah.
I would assume that both Barnegat police officers combined will be less than 20 minutes. I spoke to Detective Sergeant Coles this morning. He may be half hour, 40 minutes. He's testified before. He knows, and he was very good. He's aware of the questions.
That's why I'm raising with you now, so we'll probably be releasing the jury by lunchtime, if not sooner. So
Oh,
I want to be able to tell them what the schedule is for next week. So
And even if we call Detective Mitchell, that's going to be a very limited direct examination of him of just one issue.
all right, so the plan then will be tell the jury Wednesday the 22nd, Friday the 24th. I made sure the jury manager was able to provide any kind of specific correspondence that the jurors need to be able to explain to the employer why they have these non-consecutive days like this, because this is unusual. We don't normally do this, but I suppose it's worth actually stating on the record why we found ourselves in this position. Arguably, we could have just started the trial a week or 2 later, but we started the trial when we did because Dr. Ragassa was only available through last week. He had a long-standing vacation, which he does every year with his family. I know that obviously because the medical examiner has testified before me in the past. He goes away every year at this time, returns to his native country. So we wanted to make sure that if either side was going to call him, they would have an opportunity to do so. And to the state's credit, the state advised me that Dr. Feingold was not available until the 21st or 22nd. We anticipated that we would be able to fill that time with witnesses, but in retrospect, if we all knew in advance Dr. Ragazza wasn't going to be called, we could have started the trial later and then had more consecutive days. But lawyers have to make decisions during the course of the trial whether or not they're going to call a witness or not call a witness. So I was able to address that by making sure we would have certain trial days while Dr. Ragazza was still available. And that's what's resulted in these non-consecutive days. So I'm sure it appears unusual. It's not entirely unusual. We went through a lot of these issues during COVID, where we had to have non-consecutive days and distance people in the courtroom and have jurors in the gallery. And so in some respects, it's not as challenging as trials were during the pandemic, but that's what's resulted in these problems. And the jury's been extremely cooperative about it, and I appreciate their cooperation. a lot of tie-ups on Parkway and those kind of things, even though they're coming later.
They're on their way, Your Honor.
Thank you. Ten 13 a.m. The jurors in the jury room. Give them a minute to put down their belongings and get settled.
Sorry, if I stop.
Sure. Any concerns or issues we need to address at all? Great. Seeing none, we have some witnesses today. Mr. Gallucci.
Yes, Your Honor. Thank you. Your Honor, we called Detective, I think it's Detective Sergeant Coles.
Morning, Sergeant. Come on in.
Morning, sir.
If you raise your right hand, the court reporter will swear you in, sir.
You solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Thank you.
Take your full name.
My name is Raymond Coles, Coles.
Thank you.
Thank you, Mr. Gallucci.
Thank you, Your Honor. Welcome back.
Thank you, sir.
Detective, is it Detective Sergeant, Detective, or Sergeant? If you
Uh,
want to address you properly.
Sergeant's fine.
All right.
Thank you.
Sergeant Coles, you testified for the state that you were given certain tasks that they asked you to complete. Am I right?
That's correct.
Okay. And one of those tasks they gave you was number 2, task number 2, right?
Yes, sir.
And before you testified this morning, you and I had an opportunity to meet.
We did.
All right? And we discussed task number 2. Am
We
I
did.
right?
Mhm.
And you actually prepared some paperwork knowing basically what I was going to be discussing with you today, right?
That's correct.
Okay. So, in task number 2, I believe they asked you to identify a device, whether a device was powered on or off between the evenings of April 2nd to the afternoon of April 3rd, 2021. Am I right?
That's pretty much right there, yeah.
Okay. And which device was that?
It was Mr. Gregor's Apple iPhone 11.
Okay. And do you know how you became, well, it became in possession of your office?
It was turned over to us, I believe, by Detective Mitchell from the prosecutor's office. They believe he received the phone from the Alcoa Police Department.
Okay. So, to your knowledge, it was recovered somewhere in Alcoa and Detective Mitchell took
That's correct.
possession. Okay. And at some point you testified that in order to answer their question, you went to something called the Knowledge DB database.
Sure, the Knowledge C database.
And can you explain to the jurors once again what that is?
Sure, the Knowledge C database is in reference to essentially event logs on the iPhone, tracking different activities of what the phone's doing, applications being utilized, system services such as the device being unlocked or put in airplane mode, which we looked at for this question.
So, and when you looked at the device, I believe you testified for the state that you noticed that the phone was locked and unlocked numerous times between April 2nd and April 3rd.
It was.
Correct? Okay. Now, in addition to the Knowledge C, is it called?
That's correct.
Knowledge C, you went to something, I believe, called the Routine D, or...
Objection, leading. They've all been leading.
Well, he's a witness for the state called by the defense, so under Rule 611C, you're allowed to lead a witness associated with the opposing party, so it's overruled.
Thank you, Judge. So in addition to the Knowledge C log, you also went to something called the Routine D, or Cache Light. Am I right?
Yeah,
Okay.
that's correct.
And is that a database that actually, what does that do?
So that specific database is essentially tracking device locations on that phone. Apple is going to use that to help give predictive traffic routing, memories within your photographs, things to make your user experience better. The phone's tracking where you are so that it can give you better feedback and suggestions.
Okay. So it basically tracks the location of the device.
That's correct.
Okay. And in answering their task number 2, I believe during your testimony you identified from that time frame they asked you to identify, I believe it was April 2nd to the 3rd.
That's correct.
You identified about 60,000 GPS fixes, am I right?
That's correct.
And can you explain to the jury what a GPS fix is?
Sure. So essentially a GPS fix is going to be a ping. That's going to be the derived location where the device believes it is at that date and time.
And if you know, how does that work?
Sure. So an iPhone is going to derive location, in this case, from 3 sources. Cell towers, GPS, satellites, and harvested Wi-Fi networks. A modern iPhone, additionally, would use Bluetooth to help with that task as well. Apple has its own proprietary formula where it's aggregating all these sources together to determine a approximate area of where the device is. Usually, in this case, most of the fixes had about a 4-meter radius of accuracy. So essentially, the phone could be anywhere in approximately 12 to 13 feet spot from where it believes the device was. Some fixes were a little bit higher, around 38 meters, which if you're in the middle of a football field, essentially it's a little bit less than the distance to the end zone. So those would be the approximate locations the phone believed it was at.
As to where the cell phone is?
Correct.
So now, they asked you in your task number 2 to identify where that phone started and ended, basically.
Essentially, it was to show activity on a device. Those GPS fixes only occurred in a powered-on device, so it was to show that the device was still on and being utilized, but it also showed the purpose of where the device was going.
Okay. And I believe, can you tell us between the second and the third where it was located?
I can.
Okay, where was it?
So, I mean, on the second, the phone's seen leaving New Jersey. I believe it goes into Pennsylvania, it starts traveling southwest, and it makes it to about the southwest, approximate southwest corner of Arkansas, about 45 minutes from the Texas border.
Okay. And that was the second to the third, am I right?
That's, well, it's the second and the third.
Second and the third.
Yes.
Okay. Now, do you have the ability, if I had asked you, for the third and the fourth?
I do.
Okay. And did you actually look at that last night?
I did.
Okay. And did you, when you looked at it, did you make any observations as to the location of the cell phone between the third and the fourth?
I did.
Okay. And what was that?
Sure. So the cell phone can be seen turning around at approximately 2:45. You can see it getting onto the off-ramp. I believe it was Highway 371 and Route 30 in Arkansas. You see it get on the off-ramp, go around, and start going northeast from that point. And to put Arkansas into perspective, it's about 4 hours to go from the southwest corner of Arkansas to the northeast corner where the phone went. So, or say from Memphis, Tennessee, which is the southwest corner of Tennessee, to Arcana, Texas, which is the southwest, the northeast corner of Texas, where it hits the Arkansas border, is approximately 4 hours. So the device was 45 minutes approximately from the Texas border. It can be seen going back towards Memphis at that point. It arrived in Memphis, Tennessee at approximately 5:50 p.m. The phone can continue to be tracked until it gets to about Nashville area around 9 p.m. It looks like Mr. Gregg gets off in Nashville for maybe 15-20 minutes. As the device continues to move, he just gets off the main highway, at which point he gets back on the main highway and then stops at approximately, I believe it was 9:50 p.m. He stops on the eastern side of Nashville, past the airport, for approximately 1 hour and 15 minutes. From that point, he then drives from that section to Quality Inn Motel in, I believe it was Gordonsville, Tennessee, and stops there at around 11:45 at night.
And after that, do you see it again?
Sure. And then on the 4th, it picks up. He leaves the motel or Quality Inn Hotel at approximately 9:45 a.m. and arrives at the airport in Alcoa, Tennessee at approximately 11:15.
So he effectively does a U-turn in Texarkana, Arkansas, and heads back towards the northeast.
He does.
May I just?
Yes, sir.
Let me show you a map that I had shown you previous to you testifying. Do you recognize that?
I do.
Okay. That's Defense Exhibit D16. Is that a fair and accurate representation of where Mr. Gregor made his U-turn and where he ended up when I asked you to look and evaluate the direction he was going?
Yeah, that's correct.
Okay. And does that map show that he was at the almost the southernmost part of Arkansas at the time? And then if you travel up northeast, he's at the wherever he was in Tennessee at the time?
Approximately the Memphis area.
Okay, and that's a fair and accurate representation?
It
of
is.
that? Your Honor, I'm going to ask that that be introduced into evidence.
Any objection? D16 in evidence.
Do you know where Alcoa, Tennessee is?
Just from the map and reference to this case.
Okay. And would you say that Alcoa, Tennessee is much closer to New Jersey than Texarkana, Arkansas?
It is closer to New Jersey than
Okay.
Texarkana.
And would that be consistent with the phone traveling northeast towards the state of New Jersey?
It would be.
No further questions?
Thank you. Andy, please speak.
Yes, Your Honor.
Please go ahead.
Sergeant Coles, so based upon your prior testimony and the questions you were asked on direct just now on your map, from about 5:20 p.m. on April 2nd, 2021, until 2:19 p.m. on April 3rd, 2021, that phone and that defendant were traveling away from Southern Ocean Medical Center.
That's correct.
And so about 24 hours, that phone is going away
That's
from
correct.
Southern Ocean Medical Center. Okay. And in that period of time, that defendant and his phone never made any attempts to turn around and come back to Southern Ocean Medical Center in this area, right?
It did not.
And during that entire time, that phone was in airplane mode, correct?
Briefly, maybe around like 5:20, came out of airplane mode, but from like 6:20ish and on, it was in airplane mode until it was taken out.
And isn't it true that 25 minutes prior to the defendant turning around to come back to New Jersey, he's on the phone with his father?
He was.
And he actually turned around to come back while he was on the phone with his father.
That's correct.
Never before that.
Correct.
Now, at that point, he's 45 minutes from the Texarkana border in Texas, right?
Yes.
And then when he turns around, he makes a stop off in the Nashville area that night because he's in the area.
Briefly to stop for dinner, yes. Or gas, or I'm not sure what he stopped for, but he stopped on the eastern side of Nashville.
And based upon your understanding of basic geography, from the point that he was in Arkansas, he could have been in Mexico by Easter, correct?
Objection. It's speculation. He could have been in
That's
Uruguay.
sustained unless you can lay some foundation for that.
I have no other questions.
Any reasonable?
No, Your Honor.
Sergeant, thanks for coming in.
Thank you very much, sir. Your exhibit.
Thank you, sir.
Thank you.
Thank you.
Mr. Gallucci, you have another witness available?
I do, Your Honor. Barnegat Patrolman Daniel Dugan.
Thank you. Good morning, officer. Come on in. Good morning. If you remain standing, raise your right hand. The court reporter is actually swearing in, sir.
Do you solemnly swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Have a seat. Say your full name and spell your last name.
Daniel Dugan, D-U-G-A-N.
May I inquire, Judge?
Sure, go ahead, Mr. Gallucci.
How are you, Officer Dugan?
Good, how are you?
I'm fantastic, thank you. Who do you work for?
Barnegat Township Police Department.
And how long have you been employed by the Barnegat Township Police Department?
Around 3.5 years.
Okay, and what's your position there?
Patrolman.
Okay, and you've been a patrolman for all those years?
Yes, sir.
Okay. Did there come a time on March 28th of 2000, were you working on March 28th of 2021?
Yes.
Okay. And what were you doing on that day?
I was on patrol on the evening shift, 2 p.m. to 12 a.m.
Okay. And were you working with a partner on that day?
Yes, sir.
And who was that?
Patrolman Angel Roman. He was my FTO officer.
What's that?
Field training officer. I ride around with him for 5 weeks to understand Barnegat's policies and procedures and how they handle everyday patrol calls for service.
So you were training him?
He was training me.
He was training you?
Yes, sir.
Okay. On that day, did you have occasion to meet Christopher Greger and his son Corey?
Yes.
Okay. And can you tell us about what time that was?
I don't recall exactly.
Okay. Do you recall why?
Why I don't remember the time?
No, why you met with Mr. Greger and his son Corey?
For a welfare check.
Okay. So, did you meet with them?
Yes.
Okay. And where did you meet with them exactly?
At Mr. Greger's apartment.
Okay. And that's in Barnegat?
Yes, sir.
Okay. And when you met with them, did you make any observations of Corey?
Yes.
Okay. And what observations did you make of Corey?
Saw some bruises to his legs, arms, and hips. I also saw a minor laceration to above one of his eyebrows. I forget what eyebrow exactly. While they were in the stairway leading up to the apartment.
Now, when you spoke to them, did you speak to both of them?
Yes.
Okay. And after you spoke to them, did you have any opinion?
Objection, Judge.
Can you approach that, brother?
Okay.
Members of the jury, Mr. Gallucci's got to rephrase the question.
Besides what you've already testified to, you observed on Corey, did you observe anything suspicious?
Not between Mr. Greger and Corey. They seem to have a good relationship between each other. And that was that. We spoke with both of them, and that was really it.
Okay, and then you left,
Yeah.
right? No further questions, Judge.
Thank you. Anything from the state?
Yes, Judge.
Ms. Lentz, go ahead.
So on March 28th of 2021, you were dispatched to the Barnegat Police Headquarters, correct?
Yes.
And that would have been at approximately 7:57 p.m.?
I don't recall exactly, but yeah.
And when you got there, you spoke to a Brianna Michelot, correct?
Yes.
And Brianna is the mother of Corey Michelot?
Yes.
And Brianna had made a complaint regarding bruises on her son.
Yes.
And based upon your conversation with Brianna, you went to 900 Barnegat Boulevard, correct?
Yes.
And that was an apartment at the Atlantic Heights complex in Barnegat, correct?
Yes.
And Patrolman Roman, he also went with you to that apartment, correct?
Yes.
And when you went to the apartment, you were there to conduct a child welfare check.
Yes.
And the purpose of a child welfare check is to make sure that a child isn't in immediate danger, correct?
Yes.
And in essence, the purpose is to lay eyes on that child to make sure that they're not in imminent harm, correct?
Yes.
And you got to the apartment and you met with Christopher Greiger, right?
Yes.
And you asked to see Corey.
Yes.
And you saw Corey and you saw that he had a bruise on his legs, correct?
Yes.
And you saw that Corey had bruises on his arms.
Yes.
You saw that Corey had a bruise on his hip.
Yes.
You saw that Corey had a bruise on his chest.
Yes.
You also saw that Corey had a laceration above his eyebrow, right?
Yes.
And you spoke to Christopher Greiger at the apartment.
Yes.
And you also spoke to Corey, right?
Yes.
And when you spoke to Corey, you spoke to him in the presence of his father, correct?
Yes.
And you didn't separate Corey from his father when you talked to the defendant, correct?
No.
And based upon your immediate observations, Corey did not appear to be in distress at that moment, except for your observations of the bruises, correct?
Correct.
And you had no idea when you were at that apartment that there had been this video with the defendant interacting with his son on a treadmill, correct?
Correct.
And you have no idea how Corey actually got those bruises, correct?
Corey told me that,
Without saying what Corey said, it was just right. You had no idea. You have no personal knowledge as to how Corey got those bruises, correct?
Correct.
Now, you actually called in a referral to DCP&P regarding your observations, correct?
Correct.
No further questions, Judge.
Thank you. Any redirect?
Yes, Judge. How are you?
Good.
So, you went there to do a welfare check based upon what Brianna Micholo had reported.
Yes.
And when you went there, you met with Corey and you met with his father. Am I right?
Yes.
And what is a welfare check?
Just to make sure that the child, or if any welfare check, to make sure that that person's not in immediate danger, self-harm, anything like that. Just make sure that they're okay.
Okay. Now, Ms. Lento asked you if you were aware of a treadmill video. Am I correct?
Correct.
But you were aware of a treadmill when you spoke to them, weren't you?
After he told me about it, correct.
Okay. And when he told you about it, did he explain to you how...
Objection, Judge. It's hearsay.
Okay. Do you recall anything about the treadmill?
I recall him telling me about...
Look what the child says is hearsay, so.
So now, after you met with Corey and his father, and you did their welfare check, did you, as an officer, make a decision?
Yes.
Okay? And the decision you made during the welfare check was that there was nothing suspicious, as you just testified, right?
Yes.
And that there was actually a good relationship between the father, Christopher, and his son, right?
Yes.
Okay? And you took no further action, am I right?
I mean, we called Child Protective Services.
But you had to because it was a welfare check of a child.
Correct, yeah. When we saw the bruises, we wanted to obviously make sure that everything is okay.
You need to, as an officer, you needed to report that you had this interaction with these two people, right?
Yes.
And after that interaction, you found nothing suspicious and a good relationship between a father and a son, right?
Yes.
What made you think to yourself, as you were sitting there talking to the two of them, that they had a good relationship?
They said that the child rides his bike, they play football together. Trollman Roman said that he's observed them playing football.
Hold on. He may be qualified. Roman's statements are hearsay right now.
Gotcha. But yeah, just nothing seemed suspicious while we were on scene there.
Okay. No further questions.
Your Honor, thank you. So you wrote a report in this matter, didn't you?
Yes.
And in your report, I believe that you used the words appeared to have a good relationship, correct?
Correct.
And you use the word appeared to have a good relationship because you didn't know the extent of the relationship between Corey and his father, correct?
Correct.
And you hadn't been in that apartment for more than, what, a few minutes when you used the term appeared to have a relationship?
Correct.
And you didn't know what would have been happening in the apartment when you weren't there, correct?
Correct.
And you wouldn't have known what would have been happening in the apartment behind closed doors when you were not at the apartment, correct?
Correct.
Thank you, Judge. Nothing further.
But if you thought that there was a child that was in danger, that you were directly sent there to look at, would you have taken further action?
Yes.
Would you have written in your report if you thought that there was something amiss or something happening to a child? Would you have put in your report, nothing suspicious, seems to have a good relationship with each other? Would you have written that if you thought there was
Yes.
something wrong?
Yeah.
Thank you.
Nothing further, Judge. Thank you.
Officer, thanks for coming in.
Thanks. Appreciate it.
Mr. Gallucci, you have another witness?
Oh, I'm sorry, Judge. Yes, I call Patrolman Angel Roman.
Thank you.
Patrolman Roman?
Morning, officer. Come on in, sir. If you could raise your right hand, the court reporter is going to swear you in, sir.
Do you solemnly swear or affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
If you have to, please state your full name and spell your last name.
Full name is Angel Roman, Roman.
Thank you. Mr. Gallucci.
Thank you. How are you?
Good, how are you, sir?
I'm good, thank you. So, Officer Roman, who are you employed by?
Barnegat Township Police Department.
And how long have you been employed by the Barnegat Township Police Department?
Just under 10 years.
10 years. In March of 2021, were you assigned an assignment to train another officer?
Yes, sir.
And who is that?
Patrolman Dugan.
Okay. And you just walked out of here, right?
Yes, sir.
Okay. So, when you were training Officer Dugan, let me direct your attention to March 28th of 2021. Did you get a call to do a welfare check?
Yes.
Okay, and that was at, where was that at?
We responded to police headquarters to meet with the complainant at that time.
Okay, and that was Miss Micholo,
Yes.
Brianna?
Yes.
Okay. And she gave you information, right?
Yes.
And then you responded to Barnegat with your fellow officer, right?
Yes, sir.
In your, at that time, how many years of experience did you have? 7? Talking March of 21.
Just under 7, yes.
Okay. Had you ever done a welfare check before?
Yes, sir.
Okay. And during a welfare check, what are you trained to do?
Depending on if it's a juvenile, adult, make sure they're in good health. If they're being treated okay, if they have enough food in the house, if it's an adult, depending on the circumstances,
Now,
what the complaint is.
since you're training Officer Dugan, are you explaining to him what a welfare check should be?
Yes.
Are you telling him the things that you should be looking for in a welfare check?
Yes.
Okay. Are you explaining to him that if certain things exist, we may have to do something else?
Yes.
Okay. Now, during this welfare check, did you have an opportunity to speak to Christopher Greger and his son Corey?
Yes, sir.
Okay. And during that welfare check, did you see any bruising? Did you see any bruising to Corey?
Yes.
Okay. And describe for us where you saw the bruising.
Saw the bruising on his chest, his hip, legs, arms, and I believe there was an abrasion above his eyebrow.
Now, after you spoke with Corey and Christopher Greger, did you do anything else with respect to that welfare check?
Yes, we contacted DCPMP. I don't. Okay.
As per protocol?
Yes, sir.
Okay, and did you inform them, did you give them any information?
Yes, which wasn't the first time.
Okay, so had you seen Christopher and Corey ever prior to that day in that area?
In Barnegat Township?
Yeah.
Yes.
Okay, and where had you seen them?
Barnegat High School football field.
Okay, and what did you see them doing on that Barnegat football field?
The Gregor was throwing passes to his son on the field in the end zone area.
No further questions.
Thank you. There's nothing.
Where did you see the defendant and Corey throwing passes?
At the high school football field.
Okay, and when you saw this, where were you located?
In my patrol vehicle.
Okay, and do you remember the time that you saw this happen?
I don't recall exactly the time frame, but possibly a couple weeks to a month prior.
Before Corey passed?
Prior to my incident of doing the welfare check.
Okay, so you saw this a few weeks prior to that, and you were in your patrol car when you were able to see this?
Yes.
And you didn't stop at that point, correct?
No.
Okay. And from your vantage point, you didn't see Corey getting hurt, correct?
I think I saw him dive for a pass, but not specifically appearing hurt after diving for that pass.
Okay. Thank you, Judge. No further questions.
Thank you. Any further?
Nothing further, Judge.
Officer, thanks so much for coming.
Thank you, sir.
Sure. Members of the jury, we're going to take a short break. If I could ask you to go in the jury room while we determine the status of the other witnesses, and then we'll bring you back out in a few minutes. Thanks for your cooperation.
All rise.
All right, it's 10:48 a.m. Jury's in the jury room. Anything from counsel outside the jury's presence, or you just need a couple minutes?
Just a couple minutes, Judge.
Anything to state?
No, Judge, thank you.
All right, step off. Let me know when you're ready.
All rise. Please step out.
a.m. We're back on the record. The jury is still in the jury room. Mr. Gallucci, do you have any other witnesses today?
I do not, Judge. Judge, during the break, I had the opportunity to discuss, we were going to call Detective Mitchell, who, as you know, was the lead investigator in this case. I had, my client had, whatever. Anyway, we had discussions with Mr. Greger about whether we should or should not call him. He engaged in conversation with me and Ms. Ferrante, and then I discussed what I was going to talk to Detective Mitchell about with Detective Mitchell, and after that we decided we're not going to call him as a witness. So we're done for the day.
And you had a sufficient opportunity to be able to review all that and confer with your client and make that strategic decision?
Judge, you gave me more than enough time, and I had more than enough time to speak to Mr. Greger, not only today, but on previous occasions.
Thank you. State of minute.
No, Judge, thank you.
All right, so we at least had 3 witnesses, but fortunately we weren't able to fill more of the day. We'll release the jury from today through Wednesday, we agreed, the 22nd, right? And our intention is to then have some charge conference, at least for part of the day on the 21st.
That's fine, Judge.
All right. Any objection? I tell the jury we may be doing that just because you're entitled to know the charge in advance, so we don't sway. I tell the jury I'll probably have the lawyers in, ladies and gentlemen, I'll start coming with the jury charge with them, and this way it can be ready at the time of summations, so we don't have any delays at that time.
Judge, I think it's best that you do that, and they know that we're
Working.
endeavoring to continue in a timely fashion.
All right, so then we tell the jury the 22nd, the 24th, and then after one, right?
Yes.
All right, anything further before we bring them out?
Well, we'll talk afterwards. Afterwards, we'll talk.
11:20 a.m. jury out.
Jury out. Oh, I should be all done. Just a second. Wait, don't join the back.
Well, you don't let me complete that. We don't. I always feel bad making a person feel like they're coming out at the.
Wait.
Appreciate that. I don't think everyone does that. I do that as a matter of practice because I just appreciate how much is required for jury service and what everyone goes through. So my practice has always been that I stand and I ask counsel to stand for the jury when they come in out of the courtroom, when they come in out of the jury room. And now that we're going to have construction and road closures and parking problems and everything else, it'll be even more of a challenge to get people to be jurors. Jury out. 11:22. You can be seated, everyone. Thank you. Ladies and gentlemen, I've discussed with the attorneys and don't have any more witnesses again today. So it's another short day for you, but again, we just had some unique scheduling and witness issues in this case. That doesn't affect how you should consider the case. It doesn't change the rules and the instructions I've given you or anything like that. So we all sincerely appreciate your cooperation and patience with this procedure. I'm going to release you now for the weekend, and then we need to talk about the schedule for next week. The state has a witness we've been waiting for because of other professional obligations that they anticipate will testify on Wednesday the 22nd, and then the defense has at least one witness on Friday the 24th. I've just discussed with the attorneys, and we've agreed that I can tell you this, that we're going to be here, meaning the attorneys and Mr. Greger and I, working on the jury charge on Tuesday the 21st. Now what's that mean? So at the end of the case, I read to you a long set of instructions that we call the final jury charge, and then when you go into deliberate, that's one of the things I give you. I give you 2 copies of that to utilize for your own reference. The attorneys are entitled to know exactly what I'm going to charge you as to the elements of the offenses and a whole series of other things before they give their closing arguments or summations. So rather, and oftentimes when they're done with their closing arguments or summations, sometimes I have to continue to work on the charge then. So since we have downtime, I want to do that as much in advance as possible so as not to delay anything, not to delay your consideration of the case when they're done with their summations and I give you my final charge. So we'll be working Tuesday, but we're asking you not to come. So again, I know it's a little unusual, these non-consecutive days. So in other words, you leave today and come back next Wednesday, the 22nd. Why don't we say 9:30 or so, so you don't have to rush to get here. I know today was difficult. There was a lot of delays because of the weather. There was accidents on the parkway. I know a lot of court personnel had difficulty getting here. So then you can tell your immediate family, your employers, it would be Wednesday and Friday next week. And then obviously after Labor Day, we hope that that will be the point when we reach summation. So if you need any kind of specialized letter from jury assembly, again, I spoke to the jury manager. She'll be able to do that for you. If you have any difficulties with that, let me know. I can also assist with any type of confirmation you need. Again, always report to jury assembly. Don't discuss the case amongst yourselves. Don't form any opinions. And please, we know we have a lot of media coverage, but please don't look at it. Please don't have anyone look at it for you. Please don't let anyone talk to you about it. You're allowed to decide the case only based on the evidence introduced in the courtroom. What's on the news media, including anything we do outside your presence, is not evidence. You can't consider it. If someone talks to you about it, starts to give you information, don't discuss it with your fellow jurors, and then bring it to my attention, and we'll determine what we can do about it, and how we have to address it going forward. Don't try and visit anywhere, visit the scenes, look up anything on your own, any topics or places. I know I've said this to you many times, but I'm a little concerned when I give you a long break like this. So it's I guess a 4-day, 5-day weekend for you, although obviously you have other things in life and jobs and families that you're handling. So again, we thank you so much for that. Remember your belongings. Anything from counsel at all? No, Your Honor. All right. Ladies and gentlemen, we sincerely appreciate your service. That's why we stand for you each time you come in and out. We do that as not only a sign of respect, but a sign of our appreciation for your hard work and the fact that you're here. You're doing this, as I told you in the very beginning, which seems like an awful long time ago now, during jury selection. You can't have jury trials without jurors. So we thank you all for being here.
I'm getting good here. You're welcome.
Thank you.
You're welcome.
All right, thank you. Everyone, please be seated. It's 11:28. The jury's out of the courtroom. Juror number 13 just spoke to Officer Bennett, who just relayed to me that she had previously advised us she was, what he said, going away on the 30th? Corporal, is that what she said, going away?
A wedding. She had a wedding.
Oh, wedding. That's right. She told she had a wedding, but she thought that she would have to leave by late in the afternoon or something like that, right, by 3 o'clock. All right. And we still have enough that if she needed to be excused at that point, we still have 15. So, but I'm glad she reminded us of that. So if the jury can get the case on Tuesday the 28th, then we'll make a decision. They're still deliberating on the 30th. How we address that then? Or do we just agree she's an alternate or something like that? Or you want to talk about that?
Let me just, I like every option that you've given me just now. But let me just discuss with Mr. Greger and get his input, and I'm sure we could.
Right. You don't need to give me an answer today.
Right.
It's something we can talk about next week, obviously. So.
Absolutely.
But fortunately, we picked 16, and we still have 15. So, all right. Is there anything else you want to discuss today?
Judge, I did want to discuss, in light of us watching the video from Alcoa yesterday and anything else, and I've mentioned this to counsel and the court in the past, if the defendant chooses to testify, there are a number of things that the state can use on cross-examination, including, it's the state's position, that video. It's statements from the defendant. That would be an appropriate use of the video to use statements by the defendant on cross-examination. There's not just that video, but there's a number of other things, especially things in the defendant's cell phone. I brought one subject to a 404B analysis, perhaps to the court's attention, but there's things that wouldn't be subject to 404B, just things, I guess, that are subject to 104C. So I just wanted to bring to the court's attention how we're going to handle that. I don't know if he testifies what he's going to say, so I can't bring it to the court now. I don't really know what's going to become relevant, but I just wanted to continue to preserve the state's right to use the statements made on that footage, the statements that he's making anywhere that may become relevant, that the state may use those.
Any response, Mr. Boozer?
I've been trying to get that Alcoa video in for the last week, so if he testifies, and
Well, it would be the statements that he makes on the video.
I mean, even if you have someone that gives a custodial interview and it's later suppressed because Miranda rights weren't properly administered, the defendant testifies, he could still be cross-examined or impeached by the voluntary statement he gave, even if it wasn't appropriately warned, right, appropriately Mirandized. So, I mean, generally that's accurate. Obviously, if there's something irrelevant or not probative of his alleged guilt in this case, then it may not let it in. But, for instance, whether he was arrested for marijuana once is likely not coming in, but there's a variety of other things on there. So, we'll hold a hearing outside the presence of the jury on the defendant's testimonial election. There's no prior convictions which he can be cross-examined on, correct?
Correct.
So, obviously, but he can be cross-examined on the statement. So,
Judge, I would anticipate that his testimony, when he testifies, is going to be lengthy. I don't know how lengthy my direct examination is going to be, but I would assume, and I don't want to, I'm not telling them how to prosecute the case, but I would assume, based upon Ms. Schron's statement just now, that there's going to be a very long, it's going to be a long day when he testifies. So, and I know Dr. Bond's not going to be a whole day, obviously. He's probably going to be as long as Dr. Andrew was. So, if he testifies on Friday, which is what we plan on doing after Dr. Bodden, he could potentially go into Tuesday.
what happens, happens. All right, so Mr. Greger, I'm going to just give you some advisements now. You don't have to answer me today. This is going to be a preview of what we're going to do. At some point towards the end of the case, likely after Dr. Bodden's testimony, and outside the presence of the jury, we're going to hold a hearing called your testimonial election hearing. I'm going to make certain advisements to you, and then I'm going to ask you if you have an opportunity to confer with your attorneys and ultimately what decision you've made. But to give you some advance notice, it's my practice to always do this earlier in the case. So at the end of the state's case, and likely towards the end of the defense case, and outside the presence of the jury, I'm going to advise you the following. First, you have a constitutional right to testify or to not testify on your own behalf at this trial. I'm going to ask if you understand that right. I'm going to advise you that if you elect not to testify and thereby exercise your constitutional right to remain silent, no one may comment to the jury on your decision not to testify. Not the judge, and certainly not the prosecutor. I'll ask if you understand that. If you choose not to testify, there's a charge that I can give to the jury. That charge would be something that I would seek your consent and your attorney's consent before I gave it. But I've actually advised the jury of language substantially similar to this, both during jury selection and during my instructions to the jury after the jury was sworn. I would say to the jury as part of my final charge, as you know, Christopher Greger elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that Christopher Greger did not testify. That fact should not enter into your deliberations or discussions in any manner at any time. Christopher Greger is entitled to have the jury consider all evidence presented at trial. He is presumed innocent whether or not he chooses to testify. So if you and your attorney wanted that charge, I would give it to the jury. Near the end of the case, I'm going to have this discussion with you directly. I'm going to ask you individually whether or not you wish to testify or to remain silent. I'm going to ask you individually whether or not you wish me to read that charge to the jury. The reason that I'm going to ask you individually is there are two decisions in a criminal case which are absolutely the defendant's. The first is whether you can exercise your right to trial or you would potentially enter into a plea agreement. The second is whether or not you testify. You're represented by two competent, experienced criminal defense attorneys. You absolutely should consult with them, confer with them. They can advise you of the advantages or disadvantages. But ultimately, it's your decision. If they told you they absolutely wanted you to testify and you said you absolutely want to remain silent, you can do that. And vice versa. If they told you they think you should remain silent and you say, it's my life, my liberty on the line, I want to testify, it's your decision. At that time, I'm also going to ask you if you had enough time to confer with your attorneys. Mr. Gallucci has previously indicated he's come to meet with you multiple times in the jail. So the reason I'm giving you this notice is because you obviously have at least a week and 2 days to be able to make that final decision. I know Mr. Gallucci and Ms. Ferranti have already been talking to you about it. If you testify and you were previously convicted of any crimes, the state would potentially be able to cross-examine you on a prior conviction. The state has indicated you have no prior convictions. The state just brought up that they could seek to cross-examine you on any statements you made. Any witness that testifies at a trial and makes a statement and in the past had made a previously inconsistent statement could be cross-examined on that. And in your case, any statements previously made by you which the state thinks are evidence of guilt or inculpatory, you could try to cross-examine you on that. So when you elect your right to testify, you also subject yourself to cross-examination. In the middle of the testimony, you can't say, I changed my mind, now I'm cross-examining, I exercise my right to remain silent. By testifying, you're waiving your right to remain silent. So you need to understand those are your rights, they're important rights, and again, if you chose to remain silent, I would instruct the jury repeatedly. The prosecutor's never permitted to say something like, well, Christopher Greger never explained this, never got on the stand. That's all highly inappropriate, and two experienced prosecutors know they can't comment on your silence. So, again, I don't expect you to give me an answer now. I just want you to have a preview in advance so you don't tell me that day that you're rushed or caught off guard or you didn't realize that was going to happen. So just generally, do you understand what I said?
Yes, Your Honor.
Thank you. Anything from counsel on that?
No, Your Honor.
All right. Anything else we can do this morning?
Thank you, Judge.
All right. Thank you so much, everyone. I appreciate your
Thank you.
cooperation.